This is Michael Popok, Legal AF. We didn't have to wait long for a justice of the New York Appellate Division, First Department, to deny Donald Trump's request for an emergency stay of the judgment against him to stop the New York Attorney General from trying to collect her $450 million running with interest judgment. Donald Trump needed to post a bond of 120% of $450 million in the next 25 days or so. It'll be more with running interest. And if he doesn't post it, he does not get an automatic stay of the enforcement of the judgment. Means she can go collect by going after and liquidating his assets, which is made even easier because there is a monitor in place of a former federal judge over all Donald Trump's assets, and it's easy to find where the bank accounts are and where the money and everything is buried. But a justice of the New York Appellate Division First Department, Anil Singh, who was basically the duty judge, just happened to be around today, he decided that there would be no stay of the enforcement of the money judgment. New York is very pro-money judgment. Once you get it and you're a judgment creditor, New York courts like to support you. He did, however, in a unique twist, he did at least temporarily. This is all temporary relief until the full panel of the, which will be 6 of the Appellate Division First Department in New York, gets to hear on full briefing the issues related to the appeal. Now, I don't think that's going to be an emergency issue, and I don't think they're going to take up an emergency application. But in the meantime, Donald Trump he hoped he'd get one favorable judge to rule in his favor down on Madison Avenue, where the New York Appellate Division ceremonial courtroom is located, but that failed. However, Justice Singh did, at least temporarily for the next week or two, or for as long as the appeal lasts, he did stay that aspect of the judge's order that that banned Donald Trump from New York corporations and that banned his ability to borrow money in New York registered or chartered banks for a period of time, for a 3-year period of time. That has been temporarily stayed, but that is a Pyrrhic victory for Donald Trump. That's not the part he wanted stayed. He wanted the money part stayed. He wanted the money judgment part stayed, not the part dealing with, whether he can go borrow money or not. I guess the thinking here is that he's allowed to go borrow money now if he wants to borrow money to pay the $500 million, because Donald Trump has told the world in his filing this morning that he's short $400 million. He only has $100 million, and that's what he wants to post. He'd have to sell assets and liquidate assets. And now, basically, I guess Justice Singh has given him a little bit of a break, thrown him a little bit of a bone. So basically, if you want to go to a New York bank and see if you can get money, I'm not going to stop you from doing that. But he did affirm that the independent compliance director that needs to be installed, because this Trump organization seems to have no controls, no financial controls, no adults in the room about key issues related to finances, accounting, and proper record keeping, that the justice says that needs to be put in place. I'm not staying that. So to summarize, the judgment itself, which is the thing that Donald Trump basically, bent over and told the world, I'm not a successful business person, despite Alina Habba telling the world he had all the money to put up these bonds. He doesn't. He is short $400 million. The judge says, no, you're going to have to go post that money and go find it somewhere, but I'm going to give you access to banks because I'm going to stay that portion that says you can't borrow from New York banks during the pendency of the appeal. Donald Trump's not going to like this. This doesn't solve his problem. He's got 2 problems that are coming together. He's got another $83, now probably $86 million judgment running with interest that just got entered against him in the federal case brought by E. Jean Carroll. E. Jean Carroll's judgment is running with interest in federal court. He has to post a bond of 120% of about $85 million as well. So let's just call that another $100 million. Oh, I used to start my mornings off with chugging a huge glass of water, and then another, and then another, just to try to hydrate myself. But fortunately, I found Liquid IV. Whether you hydrate to live or live to hydrate, Liquid IV quenches your thirst faster than water alone, with 3 times the electrolytes of the leading sports drink, plus 8 vitamins and nutrients for everyday wellness, all in a single sugar-free stick. Liquid IV helps me feel revived and hydrated and ready to take on the week. The packaging is super convenient and makes it easy to carry with for when I need it most. I simply rip open one stick, pour it in my water, shake it up a little, and boom, the perfect hydrating tool to help me get back to full strength in the easiest, most accessible way possible. Just one stick of liquid IV plus 16 ounces of water hydrates better than water alone and has 3 times the electrolytes of the leading sports drink with no artificial sweeteners, plus 0 sugar in the sugar-free version. My new favorite flavor is strawberry. It's delicious and super satisfying. However you hydrate, grab your Liquid IV Hydration Multiplier, sugar-free in bulk, nationwide at Costco, or get 20% off your first order when you go to liquidiv.com and use code LEGALAF at checkout. That's 20% off your first order when you shop Better Hydration today using promo code LEGALAF at liquidiv.com. So he's got to find $100 million for E. Jean Carroll. He's got to find $500 million to post a bond for the proper amount to stop the execution of the judgment there, or assets are going to start being sold. And he was unsuccessful today to get one justice on an emergency basis to grant him a stay of that. Now, the enforcement of the judgment doesn't start until about another 25 days, so he still has time to try to get to the merits panel, which is the full body assigned to the appeal of 6 justices who we don't know who they are yet. But he can only do that and ask for a stay, having already now lost basically at the appellate level. Now, I'll be frank with you. The emergency stay issue and the emergency decision-making issue often gets reversed by the full panel. So will Justice Singh be on the full panel? He might. He may not. It has to do with whether he's going to be randomly selected for that or not. Sometimes they are. Sometimes they're not. Even if he's on the panel, when they're in full and in majority, may decide that Justice Singh made a mistake, that he either should have stayed everything, stayed none of it. We'll have to see how they parse it. But I want to manage expectations. Just because Justice Singh has ruled in a good way for democracy that Donald Trump does not get a reprieve from having to put up 120% of $450 million to stop the execution of his judgment doesn't mean that will be the ultimate decision by the 6th panel, merits panel of the First Department Appellate Division. That we're going to have to look for. But I wanted to bring this right to you. I told you in the earlier hot take that I did about 2 hours ago that we were going to get a fast decision here without oral argument. And we did. I think they went down there. There was objection. The judge heard some argument, and boom, we got, as you saw up on the screen, we got this 1-paragraph decision, which just rocked Donald Trump's world. So we'll continue to follow everything about the judgment and enforcement, and we're going to do it at the midweek edition of Legal AF on Wednesdays and the weekend edition on Saturdays, 8 p.m. Eastern Time, only on the MeidasTouch Network and on Legal AF. So until my next hot take, until my next Legal AF, this is Michael Popok reporting.
Love this video? Make sure you stay up to date on the latest breaking news and all things Meidas by signing up to the MeidasTouch newsletter at MeidasTouch.com/newsletter.